So it takes a lot to get an attorney excited about something. And I have a new matter that came in recently. And in doing research in relation to this matter, I found a case from 2012 from the New York Supreme Court, which is the trial level court in New York. The highest court is the Court of Appeals. And this was a decision from 2012 in Westchester, Judge Fran Connolly, who is a fellow hiker. And in this case, Judge Connolly dealt with issues from far and wide. And so, we're all familiar with the ketubah in the Jewish religion. I am developing a greater familiarity with the Mahr, M-A-H-R, which is the Islamic marriage contract. And in this case from 2012, Judge Connolly addressed a situation where the parties had a trial in the United Arab Emirates relating to a Mahr that had been entered into between the two of them at or about the time of their marriage. And in this marriage contract, the husband had agreed to pay, I think what they refer to as a deferred dowry of $250,000 to the wife. And so the parties litigated these issues in full in the United Arab Emirates. And the wife in the United States was seeking to enforce the Mahr against the husband so that she could enforce her rights to things like spousal support and the $250,000 payment. So the reason this case is exciting from an attorney's perspective, and probably for no one else, is because it raises issues that we rarely see in a typical divorce action in Westchester County or in New York City or the like. And it raises cases from the New York Court of Appeals from 1983, where Judge Wachtel, some people might recognize that name, rendered a decision with respect to a ketubah and distinguishing between religious components and civil components of a contract, and enforced a specific term of the ketubah. And again, the ketubah was really one of the original prenuptial agreements. It was one of the original documents that recognized rights of a married woman. And so other issues that come up in this case are dealing with a foreign judgment and the validity of a foreign judgment, whether the foreign judgment and the findings of the foreign court violate the public policy of the state of New York, doctrines of comity, C-O-M-I-T-Y, maybe it's comity, and in relation to recognizing the judgment of a foreign country, the document of the neutral principle of laws, and this involves a decision of the United States Supreme Court from 1979, Jones v. Wolf. So that's why this is a sexy case, an exciting case for an attorney. All of these different precedents, these different legal concepts, and the bottom line is that we're dealing with whether a New York court will recognize the validity of a Mahr or Islamic marriage contract in a particular case. So I may be litigating that issue soon, and we'll see, but it's a fascinating area of law. So if you have any questions about ketubahs or Mahrs or anything else in the matrimonial law area, feel free to contact me, Ken Novenstern from Fredman Baken Novenstern LLP. Take care.